Good evening, everyone. I can see that people are still joining, but I'll start saying hello now anyway. You're all very welcome, and thank you for joining us this evening for our seminar on sexual violence and harassment in schools, best practice and remedies. It's brought to you by the Garden Court Chambers Education Law team, and we have brilliant speakers who I'll introduce you to shortly. Very briefly, my name's Gráinne Mellon. I'm a barrister in Garden Court and I practice in public law, education, health and social care law, lots of judicial reviews and some civil claims for damages under the Human Rights Act. And we're going to look at both of those shortly. And today we're going to touch really on the context of abuse and harassment in schools, looking at peer-on-peer abuse in particular, the regulatory framework and current guidance from the Department of Education. And then finally, as I've said, some legal options and remedies for those affected by abuse and harassment in schools, in particular judicial reviews, civil claims, including under the Human Rights Act. So we organised this seminar really because we're starting to see more of these cases, and it's ironic really that there's so few cases and so little case law as well, particularly because this really is a huge issue in schools and has been described as the Me Too movement for education. So Andrew and I have been involved in a case together, and we would love to hear if you too have had experiences of these cases and what happened with them. So really as much information sharing as possible, and we'll come to some questions at the end, and there'll be an opportunity for any comments or any information sharing at the end too. So thank you for joining us. And I would like now to introduce you to the two other speakers. I'll be speaking at the end, but luckily, first and foremost, we have Nicola Braganza, who will be speaking to us shortly on the context of peer-on-peer abuse and some of the statutory framework and guidance. Nicola is a public law barrister here at Garden Court. She specialises in equality and discrimination, human rights and civil liberties work, and has a broad range of experience in Equality Act claims, Human Rights Act claims and judicial reviews. She is due next month to be appointed a QC, so we're really happy about that, and I think I can sneak in that accolade a month early without causing too much trouble. She's also sits part-time as an employment judge and also in the Special Educational Needs and Disability Tribunal. The same with our next speaker. The CVs are so long that I'm going to have to leave it there, but say.
Is that Gráinne that's frozen?
Yes, I think it is.
Well, maybe if we give Gráinne a few seconds, and otherwise I can just kick off.
Yes.
Gráinne, we lost you.
I'm so sorry.
We lost you just as you were introducing Andrew.
Okay. Well, let me keep going. Sorry about that, Andrew. That's not very good luck for the introduction that you deserve. Hopefully it won't happen again. Andrew is an associate solicitor at Leigh. He specialises in representing survivors of abuse in civil claims for compensation. He's worked on claims concerning children's homes, voluntary organisations, religious organisations and sports clubs, and has also been involved in a number of these peer-on-peer abuse civil claims, and is really a leader in this field. And certainly we've done one case together, but he's certainly got experience of a wide range, and again, rising star in all the directories, lawyer of the week, etc., etc. So thank you, Andrew, for joining us. And I think we can now make a start. So we'll hand over to Nicola for her section.
Thank you, Gráinne. Thank you very much for that very kind introduction. And thank you, Andrew, as well. Very much looking forward to hearing presentations from you both. I'll start by sharing the screen and let me know that whether it's worked. Right. Yeah, is it all good?
Yes, that's working.
Great, excellent. Thank you very much. So I'm kicking off this evening's seminar with an outline of context and background and the overview of the statutory framework. So we start well, we'll start well before then, but I have started with the Women and Equalities Committee report, which was published on the 13th of September 2016. And already at that stage, it uncovered serious, widespread sexual harassment and violence in schools across England, on which it demanded that urgent action be taken. In particular, the evidence that it heard showed that sexual harassment and abuse of girls was accepted as part of daily life. Children of primary school age were learning about sex and relationships through exposure to hardcore pornography. Teachers were accepting sexual harassment as being just banter, and parents were struggling to know how they can best support their children. What the evidence also revealed before the committee at that stage, this is going back to 2016, was that almost a third, 29% of 16 to 18-year-old girls say they experienced unwanted sexual touching at school. Nearly 3/4, 71% of all 16 to 18-year-old boys and girls say they heard terms such as slut or slag used towards girls on a regular basis. 59% of girls and young women aged 13 and 21 said in 2014 they'd faced some form of sexual harassment at school or college in the past year. And the committee also found that it was particularly girls across the country that suffered, and that the majority of perpetrators were boys, the majority of victims girls, but they did highlight that it was essential that the negative impact on both boys and girls is recognised and addressed. They also pointed to the lack of centralised data collection, and that there was underreporting and a lack of consistency in schools reporting sexual assault to police and other authorities. And they made a number of recommendations, including as to personal, social health and education, economic education and relationships education, and making that a statutory subject, having cross-government strategy and whole school approaches to tackling sexual harassment, sexual violence, teacher training, specific recommendations for Ofsted around inspection, legislation for every school to take appropriate action, and also Ofsted and independent schools inspectorate to assess schools. There was a response from the government in November 16, but it didn't commit to further legislation, relying on existing requirements being sufficient. So that was then. Moving on, fast forwarding to June 2020, and the Everyone's Invited website is founded, which was a space to share, founded by Soma Sara, a space to share and expose rape culture. And the website defines rape culture as when attitudes, behaviours and beliefs in society have the effect of normalising and trivialising sexual violence. This culture includes misogyny, rape jokes, sexual harassment, online sexual abuse, upskirting, non-consensual sharing of intimate photos, cyber flashing, and sexual coercion. When behaviours such as these are normalised, this can act as a gateway to more extreme acts such as sexual assault and rape. So that was June 20. I'm sure we all remember March 21, 3rd of March, the horrific abduction and rape and murder of Sarah Everard, which then prompted a nationwide outcry, predominantly female protest across the country over the endemic sexual harassment and violence. As at March 21, the Everyone's Invited website, as reported on the BBC, had 8,000 allegations made by school pupils. By April, that had risen to thousands of testimonies, and by late September, 54,000. That then in turn prompted the NCPC dedicated helpline, launched in April, and the Ofsted Rapid Review, which was announced in March 21 and led to the review being published in June, on the 10th of June 21. And very concerningly, echoed very much what I've just been through going back to 2016 and what was before the Women's Inequalities Committee. It was an 8-week inquiry. They visited 32 schools and colleges. Over 900 children and young people were asked questions about the prevalence, and they found that there was serious prevalence of peer-on-peer sexual harassment, sexual violence, including online in their lives and the lives of their peers. And the inspectors were so struck, and this also then featured into their recommendation, by the widespread prevalence, that their recommendation was to act on the assumption that there was a problem of sexual harassment even when there was no direct evidence or complaints about it. The chief inspector at the time said, and I've set that out, it's alarming that many young children and young people, particularly girls, feel they have to accept sexual harassment as part of growing up. Whether it's happening at school or in their social life, they simply don't feel it's worth reporting. So what did the review find? Well, as I say, it found that sexual harassment, online sexual abuse was prevalent. It found that it was so commonplace that those suffering it could not see the point in reporting it. It was told that by girls that sexual harassment, online sexual abuse such as being sent unsolicited explicit sexual material, being pressured to send nude pictures, nudes, much more prevalent than adults realise. The statistics are shocking. 90% of girls, nearly 50% of boys said they'd been sent explicit pictures or videos of things they didn't want to see, and it happened a lot or sometimes to them or their peers. 92% of girls, 74% of boys said sexist name calling happens a lot or sometimes, so much so considered as normal. And also that there was a real reluctance by children and young people, especially girls, to talk about it. And that arose for a number of reasons. They feared being ostracized. They feared getting their peers into trouble. They feared that a matter that they expressed concerns at would then be taken out of their control in how it was dealt with. So Ofsted, in its review, made a number of recommendations. I've set out the recommendations there to, as I say, assume that there is a problem, adopt a whole school college approach, have carefully planned RSHE curriculum carried out with sanctions and intervention, provide support, provide training to staff and governors, listen to pupil voice, as is required, the statutory guidance to follow keeping children safe in education, record keeping and analysis, improve engagement with multi-agency safeguarding partners. The government was to consider its finding as it develops the online safety bill, develop an online hub to access most up-to-date safeguarding guidance, and provide guides for children and young people to explain what will happen after they speak to school staff. So that's the background. What are the legal duties? So schools and colleges have statutory duties to safeguard and promote the welfare of children at their school or college, and they're required to have regard to guidance issued by the Secretary of State. Section 175 of the Education Act requires schools and colleges to make arrangements for ensuring that such functions are exercised with a view to safeguarding and promoting the welfare of children. And that's replicated in the Education Independent School Standards Regulations 2014 for proprietors of independent schools. In the case of academies and free schools, the Academy Trust, to ensure that arrangements are made to that end. And for non-maintained special schools, the regulations of 2015 require that requirements to be complied with, and a condition for approval are that arrangements are in place for safeguarding and promoting health, safety and welfare of pupils. The guidance is made up of first of all, the Keeping Children Safe in Education, last updated in September 21, and there is currently a consultation open on that to the 8th of March, intended to be implemented in September 22. Statutory duty to cooperate with safeguarding partnerships, and that's as set out in the Working Together Safeguard Children 2018 guide. There is the sexual violence and sexual harassment between children in schools and colleges, which I know Andrew and Gráinne are going to be speaking more to in their presentations. The requirement to have behaviour policy and measures in place to prevent all forms of bullying, cyberbullying, prejudice-based and discriminatory bullying. And then also relationships education for primary and secondary pupils is now mandatory. I've listed there, I won't read out each one, but you'll see further extensive resources for guidance in respect of sexual harassment and violence and peer-on-peer abuse. And then following that guidance, In addition to section 175, there are then the duties under the Human Rights Act. So section 6 makes it unlawful for a public authority to act in a way that's incompatible with the ECHR. Now, for our purposes, the relevant articles are 3, 8, and 14. And 14 is to be read combined with 3 and 8. It's not a freestanding right not to be discriminated against. And then as well, Protocol 1, Article 2, the right to an effective education to be interpreted in line with the UN Convention on the Rights of the Child. And being subjected to sexual violence or sexual harassment may breach any of those rights depending on the circumstances of the individual case, depending on the nature of the conduct. Where it will fall in terms of Article 3 and 8, it will have to meet a minimum level of severity to engage Article 3. If it does not, it may nevertheless fall foul of Article 8. And Article 8 may apply to verbal abuse without physical violence. And I'm just now refer to 2 recent Strasbourg cases. One is Association Accept and others in Romania. And that was of interest because it concerned homophobic abuse in a public place and referred to how to make out your Article 3 claim. So a minimum level of severity must be reached by the ill treatment that's complained of for it to fall within the scope of Article 3. The assessment of the minimum is relative, so it will depend on all the circumstances of the case, the nature and the context of the treatment, the duration, physical and mental effects, and in some instances, the sex, age, and state of health of the victim. And it is not only limited to physical ill treatment, it can cover psychological suffering, and in which case the treatment can be categorized as degrading when it arouses in its victims feelings of fear, anguish, and inferiority capable of humiliating and debasing them. The court further reiterates that discriminatory treatment as such can in principle amount to degrading treatment within the meaning of Article 3 when it attains a level of severity such to constitute an affront to human dignity, which in my view will plainly engage what we're discussing this evening, sexual violence, sexual assault in schools. Discriminatory remarks and insults must in any event be considered to constitute an aggravating factor when considering a given instance of ill treatment. And in associating the other part of interest, the court said at paragraph 63, looking at Article 8, private life is a broad term that is not susceptible to exhaustive definition and covers physical and psychological integrity of a person. Such elements as a person's sexual orientation and sexual life may be protected by Article 8. And then it said that for Article 8 to come into play, the court must consider the alleged violation must attain a certain level of seriousness and be committed in a manner causing prejudice to the personal enjoyment of the right to respect for one's private life. And the next case, which is of interest and is within an education context, this was about FO in Croatia, about a teacher verbally abusing a student. And the court set out that the principles of Article 8 may also be relevant in an education context. While under Article 2, Protocol 1, the state has an obligation to secure to children their right to education, the sending of a child to school necessarily involves some degree of interference with his or her private life under Article 8. Moreover, functions relating to an internal administration of school discipline, inherent part of the education process. And then jumping down to the next paragraph, the essential role of the education authorities is to protect the health and well-being of students, having regard in particular to their vulnerability relating to their young age. So that is how, using that you can claim within your challenge that Article 8, and depending on whether it's reached the minimum threshold, Article 3 is also engaged and breached. So then we have the Equality Act. Now, under the Equality Act, the relevant parts for our purposes are, first of all, Section 13, direct discrimination, where less favourable treatment arises. Indirect discrimination, where there is a practice criterion or provision applied to all, but causing disadvantage to a particular group with protected characteristics, and disadvantage that cannot be justified. And then finally, victimization. So raising anything under the Act, as a result of which the individual raising it is then subjected to a detriment. And that arises in connection with certain protected characteristics as defined within the Act, and those are set out there, and I'm sure you'll all be familiar with those. In the education context, Section 85 provides that the responsible body of the school must not discriminate against pupils in the way it provides education, the way it affords access to a benefit by not providing education access to a benefit, or importantly, excluding them or subjecting them to any other detriment. Now, detriment will be anything beyond the minor or trivial. It has a very wide meaning, protect against any disadvantage, whether or not the person subjected to discriminatory treatment was aware of it at the time. And then in addition to those provisions, there's the public sector equality duty, and that sets out Section 149. On public authorities, there is a duty to have regard in three respects. One, to eliminate unlawful discrimination, harassment, and victimization. Two, to advance equality of opportunity. And three, to foster good relations between different groups. And that duty applies to all protected characteristics. Whenever significant decisions are being made or policies developed, due regard must be had to the equality implications. So, for example, the elimination of sexual violence and sexual harassment. The duty requires that there's focus on key issues of concern and how to improve pupil and student outcomes. So, for example, where girls are routinely sexually harassed, not only are they then victims of sexual harassment being discriminated against, but that's also likely to impact on their quality of opportunity by the impact on their education. And schools need to consider what information they need to have due regard of, and importantly, there needs to be evidence of that, the importance of good record keeping and the importance of monitoring of sexual violence and sexual harassment reports. And we see that also in the case law. So Bracking sets out the core principles to be followed in the application of the public sector equality duty as affirmed in HOTAC. And equality duties are an integral, important part that meet the aims of our anti-discrimination legislation. They form an important evidential element. In this case, it was set out the duties on the minister or other decision maker personally. The risk must be assessed, the extent of the adverse impact before and not merely as a rearguard action. And the duty has to be exercised, the duty to have regard in substance and with rigor, with an open mind. It is not a tick box exercise. It is non-delegable and a continuing duty. And so finally, I come then to a most recent decision on the PSED, which is helpful. It concerned the appointments of officials to important posts responding to the pandemic. And whilst the challenge was not successful on many of its grounds for a number of reasons, including limitation and standing, there was a finding by the court, and this was Lord Justice Singh and the judge in charge of the administrative court, Mr. Justice Swift, of a breach of the PSED. And the court considered the evidence relied on to make out that, in fact, the decision makers had had regard to the PSED, and set out in its reasoning that there must be some evidence of what precisely the decision maker did in the circumstances of these cases to discharge the obligation. There is no evidence from anyone saying exactly what was done to comply with the public sector equality duty when decisions were taken. And on this is questioning your relevant decision maker on what the evidence is, both on the time and in compliance with the continuing duty. Very often is the key to exposing the extent of steps, the understanding and awareness of the level of the problem in their particular school or college. And so I think crucial in requiring schools to comply with their duties and obligations and ensure that the crisis that it is properly tackled. So those are my slides. Thank you very much. Thank you for listening. And I'll pass over to Andrew. I'll stop sharing. There you go.
Great, thank you, Nicola. That's a really helpful overview and actually set me up quite well for my talk. So perfect. Thank you also, Gráinne, for the introduction. I'm just going to share my screen. If you just give me 1 second. And then hopefully is somebody will tell me if that's not showing, but hopefully it is. So just to mention again, my name's Andrew Lord. I'm an associate solicitor at Leigh, and I represent survivors of abuse, and unfortunately that has in recent years included a number of cases on behalf of victims of sexual violence and harassment by their peers. I'm looking at this from the perspective of somebody who's looking at compensation claims. And so I see cases when they're at late stages where there has been a breakdown or there have been issues. I know there is some mixed experience within the audience today. So I think just to reiterate Gráinne's point that it would be fantastic to hear from people if they've got any different perspectives on this very delicate and sensitive issue. I'm going to start just showing you a couple of headlines. I'm not going to go through them all one by one. I'm just going to flash them on the screen here because Nicola has actually done a very good job of explaining the background to this issue. But what you can see here is that for a number of years, this has been a real issue that's gaining real prominence, and it's something that a lot of people have been trying to tackle. This last headline, just a couple of weeks ago, actually looks at the Harmful Sexual Behaviour Support Service. It's a new helpline which has been set up with support from the Home Office and the Department for Education. So this is very much a live issue that is still with policymakers at the moment. I'm going to look very specifically at the sexual violence and sexual harassment between children in schools and colleges advice. That is advice from the Department for Education, first published in December 2017. It is not statutory guidance. It highlights best practice and cross-references other advice and statutory guidance, which Nicola went through many of them before. So the guidance isn't to be read in isolation. The guidance is on its third version, in September 2021 is the version we're currently using. It's a 53-page advice, so quite thorough, you would assume. It contains information on issues such as education as preventative measure, support for schools, and has a number of case studies about ways that you may want to overcome some of the issues that present themselves. As I put here, it's advice for this long list of people, but what is interesting, it's not advice for all staff. So something to bear in mind is that this is not something that would necessarily need to come to the attention of, for example, teachers, classroom assistants, playground attendants, and other staff not listed there. So what is it that we're talking about? It's actually set out within the advice. Sexual harassment, it's noted that it's not exhaustive list, but it can include sexual comments, jokes, or taunting. Can include some physical behaviours. So here we're thinking about intentionally brushing past somebody or interfering with their clothing. And in those circumstances, there needs to be consideration as to whether it's tipped the balance into something that can be classed as sexual violence. And then also online sexual harassment. So you are thinking here of sharing of intimate images, upskirting, sexual exploitation, other issues such as those. Sexual violence is a little bit more straightforward in some regards, in the sense that it is the definitions under the Sexual Offences Act of 2003. So here you're talking about a rape, assault by penetration, sexual assault, or causing someone to engage in sexual activity without consent. And again, the advice does talk about consent in some detail. So we're talking about freedom and capacity to choose, and it also makes clear that consent can be specific to a sexual activity but not another, and that it can be withdrawn at any point in time. It does set out the ages for consent, and that sexual intercourse without consent is classed as rape, and sets things out very clearly. So what are we told to look out for within the advice? It makes clear that these sorts of incidents can occur between two children of any age and sex. It can involve groups of children. And the advice makes clear that staff should be aware it's more likely that girls will be the victims, and it's more likely to be perpetrated by boys. Children with special educational needs and disabilities are 3 times more likely to be subjected to abuse than their peers. The advice does talk specifically about some of the barriers to recognising abuse in children with special educational needs and disabilities, and notes that if that is something that arises, that will need close liaison between the designated safeguarding lead and the special educational needs coordinators or SENCOs. The advice also highlights that LGBT children, or those perceived to be LGBT, can also be targeted. And it does note that staff can also be the focus of sexual violence and harassment, albeit it isn't the main focus in this advice. Some more general points just to bear in mind. So that it does make very clear within the advice that all staff are to maintain the view that it could happen here. Note the reference to all staff when the guidance is actually specific to the people who should be looking at it, and it isn't necessarily aimed at all members of staff. So that's a consideration that's going to have to be looked at on a local level. Zero tolerance approach to sexual harassment and violence is advocated. So this is the idea, or the attempt to combat the downplaying of some sort of behaviours, because otherwise if you downplay those behaviours, you can create environments which are conducive to abuse. A whole school college approach is important. So here you are thinking about things like what systems are in place to allow children to make confidential disclosures, or making sure that there are transparent, easy to understand procedures for staff to know what happens when a disclosure is made. I've already mentioned that relationship and sex education is now mandatory. This is an issue that came in for particular criticism within the Ofsted rapid review last year, noting that there was insufficient time given to this subject and that the curriculum planning was particularly poor. So this is something that I think it really needs some real attention. The recommendation from Ofsted was that schools and colleges should be providing high quality training for teachers so that they're able to deliver this effectively. And then when considering a disclosure, the schools or colleges, they need to consider the different factors at play here: age or the developmental stage of the children, whether there's any power imbalance. And in all, they're trying to figure out whether what they are facing by way of disclosure could be classed as harmful sexual behaviour. This is an umbrella term. It's widely adopted in child protection, but it is I would say it's quite a complex issue, and I do query, or I'd be interested to know, speaking to head teachers and designated safeguarding leads, whether they feel like there are enough training opportunities out there to actually help assist them in figuring out what will constitute harmful sexual behaviour. So a quote here from the advice: reports of sexual violence and sexual harassment are extremely complex to manage. I'm sure we can all completely understand that sentiment. It does note within the advice that this is going to require some very difficult professional decisions quickly and under pressure. And there's a real emphasis on pre-planning and making sure that there is effective training and policies in place. The response is dealt with on a case-by-case basis. You have the designated safeguarding lead or deputy taking the leading role and using other agencies as required. And the advice does have some recommendations of steps to take, but they firstly have some important considerations as well. All victims to be reassured that they're being taken seriously. All is emphasised within the advice. The wishes of the victim and any ongoing risks. This is the idea that it's essential to try and provide as much control as is reasonably possible to a victim, of course, balancing with the duty to protect other children and ongoing risks to the victim or the alleged perpetrator. The nature of the allegations, so there needs to be consideration about whether a crime is being committed. Is this a sustained pattern? And again, there's reference to reports of rape and assault by penetration, likely to be especially difficult, given the potentially close proximity of the victim to the alleged perpetrator whilst the facts are being established. And it does talk of schools, schools should consider whether alleged perpetrators should be removed from any classes that they share with the victim, and also give consideration to whether there's any contact around the school or on transport into school. Again, age and developmental stage of the children needs to be considered, as well as any power imbalance between the children. And then you need to figure out how best to support and protect the victim and the alleged perpetrator. The advice makes clear victims of sexual violence are likely to be traumatized, and it talks about how they may be unable to maintain a normal classroom environment, but you also need to ensure you avoid isolating the victim from any support groups. And then it also mentions with the alleged perpetrator, there needs to be some consideration as to whether this is a sign of abuse elsewhere or just a sign of wider issues to be addressed. So once the disclosure has been made, the advice suggests there's 4 likely scenarios in how you are going to be dealing with this. They are set out here on the slide. They're mostly, I assume, self-explanatory, but just very quickly, managing internally, you're looking at cases of sexual harassment where it's perhaps been a one-off incident. Obtaining early help. So this is where you request multi-agency early help where there has perhaps been some non-violent harmful sexual behaviour that has the potential to escalate into sexual violence. You then have referral to social care and reporting to the police. Reporting social care where a child's been harmed or is at risk of harm or is in immediate danger. Reporting to the police, it's noted that if there's ever a report of rape or assault by penetration or sexual assault, the first protocol is a report to the police. And that's even where the children involved are under the age of 10, so criminal responsibility may not be ascribed. But it's noted that the police will take a welfare role in those situations. It does also make talk about the advice talks about safeguarding and supporting the victim and the alleged perpetrator. And I've just put down a couple of the points here that are given consideration. Again, having experience of representing survivors or victims of the harassment and violence, the particular point for me is that the needs and wishes of the victim should be paramount in any response, and allowing them, where possible, to maintain their normal routine. Nicola went through before the legal duties, so we know there's a statutory duty to safeguard and promote the welfare of children at school and college. And when you're dealing with a disclosure, you've got to consider here providing an education safeguarding the victim, whilst providing education and safeguarding support to the alleged perpetrator with any disciplinary action. It is recognised this is a very difficult balancing act, and that there is particular regard that needs to be had to stress and trauma that might be caused to a victim when they are within the same institution as the person that they are alleging subjected them to sexually harmful behaviour. And it talks about the need to strike a balance between the management of risks and the rights of the child who has been accused but has not been convicted. And the advice is that in those situations, schools and colleges want to liaise carefully with police investigators to develop an appropriate set of arrangements. But there is also consideration that needs to be had to things like other children perhaps taking sides, whether there'll be any bullying, the use of social media. So it's an incredibly complex situation, and one that had a similar accusation being made amongst adults in the workplace. There may be very robust systems in place, but where you're looking at children, there's competing interests here. If the perpetrator is to be excluded, then of course the decision has to be lawful, reasonable and fair. And the advice actually points out that schools can be a significant protective factor for alleged perpetrators. If a child is convicted or receives a caution for a sexual offence, then the advice says that the school should update its risk assessment, ensure that there are relevant protections in place for all children at the school, and if the perpetrator is to remain in the same school as the victim, then they need to be very clear as to what their expectations are about the perpetrator's behaviour now that they've been convicted. I'm not going to spend too much time on this, but just to highlight that the rights that Nicola mentioned are actually detailed within the advice, and Gráinne is going to be having a look at this, I believe, shortly. And similarly with the Equality Act and public sector equality duties, they're also detailed or listed within the advice as relevant considerations when tackling a disclosure. So that brings me on to best practice. The advice has 4 case studies, and I've listed there what the case studies deal with. Now, it's difficult because I think a lot of the guidance makes, or the advice makes clear that it is case-by-case basis, and it would frankly be impossible to have a very detailed list of what somebody should do in any given situation. But it is notable to me that the case studies are not terribly extensive. Some of the factors that the advice points out itself, so for example, if a disclosure is made by a child with special educational needs and disabilities, the advice makes clear that it will have additional barriers in place, but it doesn't give any case study on what to do in that situation. It also doesn't cover things, the case studies don't cover situations where perhaps you have a 1-form entry school, and so there is only 1 class group per year, and how it would be that you will ensure that children aren't being educated alongside one another. So very complex issues that need to be grappled with, and unfortunately the case studies aren't terribly detailed. I have given some discussions in the past with safeguarding leads, and I thought it'd be helpful here just to highlight some of the things that I mentioned to them as possible practice points for them to consider. They all seem relatively straightforward points, I'm sure you can agree, but just running through them. Being proactive, consider implementing a separate peer-on-peer abuse policy, make sure you're reviewing the adequacy of staff training and communications, and check all staff understanding the guidance and their role in tackling these issues, and encourage a situation where there's an openness amongst staff, where they there's an opportunity to challenge any incorrect perceptions. Review education on offer to children. Again, we had a chat before about relationship and sex education. Ensure it is effective and make sure that there are sufficient resources dedicated to that. But also schools and colleges might want to consider capitalising on that by enhancing general studies with age-appropriate lessons, and also consider whether external speakers may want to come in. And prepare a plan of action. Again, just knowing as far as possible what somebody will do in advance when an allegation is made, I think could be invaluable. So it's probably speaking to your local resources, finding the specialist support services in the area, and just being ready to tackle this head on. As I said right at the start of this, that I see matters when they have there've been some issues down the line, and I believe often a lot of the families talk about feeling a lack of support available once a disclosure is made. So I think proactiveness is incredibly important. So I have put here questions, but I believe we're going to take them at the end. If anybody does have any questions, my contact details are there on the slide. So if you're unable to ask your question today, do feel free to drop me a line at any point in time. But otherwise, I think I'm going to hand over to Gráinne. So I'm just going to stop sharing my screen and leave it with you.
Thank you very much, Andrew. That was really comprehensive review of best practice and the guidance, and thank you for it. I'm now going to try to share my slides. Yes, okay. So I'm going now to look in a little bit more detail at some of the legal remedies for what we've been calling peer-on-peer assault or harassment in a school context. And I'm going to concentrate on claims against the school or the local authority rather than against, for example, the alleged perpetrator. And Nicola has touched already on some issues around the Equality Act, the PSHE, and touched on discrimination, etc., from the purposes, including underemployment legislation. So I'm not really going to touch on that, but I am going to focus on the first three remedies available on the board, which are negligence claims, claims under the Human Rights Act, and judicial reviews. And I suppose I begin with what Andrew finished with, which is that nobody wants to be at this point. By the time we're at the point of bringing a civil claim for damages or even an urgent judicial review, for example, in relation to urgent risk or urgent safeguarding, it's already got quite bad. So just to reiterate that the whole focus of the statutory guidance and everything is on stopping us getting to that point, on the policies, on the training, on addressing the culture, and really taking steps to make sure that children are protected in this environment. But we're looking at what happens when that's not the case, and what the remedies might be in particular for a child or a young person or their family. And I wanted just to start by mentioning a case that Andrew and I worked on, which settled last summer, and certain information is publicly available. So I can just briefly tell you about it to put in context what we're going to look at shortly in terms of negligence and human rights claims. So Joel is not his name, it's a pseudo name, but he was a very young primary school aged boy. He was 6 years old, and it's one of the striking features of this case is just how young he was. But we see the statistics in primary schools and in fact know that sadly it's not that unusual. And he was sexually assaulted outside the school, and his parent reported it to the school and was assured that sufficient safeguarding measures were in place. They didn't report it to the local authority. When the family did, the local authority said it was normal exploration between children, and some safeguarding measures were put in place in terms of supervision, or at least in theory were put in place, but both children remained in the same class. And the mother was assured that things were fine. The child then disclosed that there had in fact been 2 previous assaults, one which was before the assault in the home, and crucially one which was afterwards, when the school were on notice of the risk in this case. When that disclosure was made, the child was immediately removed from the school. And further down the line, we were instructed to bring a damages claim. And we did so both in negligence and on the basis of breaches of Articles 3 and 8, which is the protection against inhuman and degrading treatment and private life, encompassing as it does psychological and physical integrity. And we were alleging a whole raft of things, but in essence that the school failed to conduct a thorough investigation, failed to adequately train their staff, failed to put in place sufficient measures to prevent further sexual assaults from taking place, and that all of this was negligence and a breach of Joel's human rights. And as many, indeed, civil cases, but also these types of cases generally, it settled at a very early stage, and the local authority did concede that there had been a breach of duty, but didn't concede liability. And there was a settlement, which in the usual way had to be approved by the High Court, given the age of Joel. So that's just one example of the types of cases where the legal remedies we're about to look at offer some solution, albeit, as I've said, after the event, and therefore not what anybody really wants to have to deal with. But Andrew will also, I think, maybe have some helpful tips in terms of these types of cases, and we'll hear shortly from him. But that's Joel's case. So I just want to very quickly look at negligence claims, because it's right that a school can own a duty of care to protect a pupil from harmful behaviour by other pupils, even if it occurs outside school. And I've put up a case of Bradford and Smart, which is quite old now, although no breach of duty was found on the facts of that case, but it does establish the principle that there can be liability in negligence in those circumstances. A school's duty of care to its pupils during the school day, it's also non-delegable, and that's the Woodland and Swimming Teachers Association, where the Supreme Court affirmed that a school owes children a duties of care even when they're carrying out activities provided by an independent contractor, in that case swimming lessons. And the case of Shaw and Redbridge follows on from Bradford Smith and makes it clear that a school owes a duty of care in circumstances where there's a foreseeable risk of physical or psychiatric injury. So really, when you're thinking about a negligence case arising from sexual assault or harassment in schools, the issue is what the school either knew or ought to have known of the abuse. So you're looking at the foreseeability of that. And if there is an argument that an assault has taken place and not enough or anything was done to prevent future assaults, then you're probably on quite strong territory in terms of negligence. Liability can be difficult and will turn on its facts, and we'll come to that shortly. So just to reiterate that the issues that will need to be considered are the usual negligence issues, three of which are set out on the slide in terms of what steps could have been taken and would they have worked. And what I will say is that I think the guidance which Andrew has taken everybody through is going to be a useful starting point in saying what the right thing to do in that situation would have been and what a reasonable professional would have done in that situation. So it is relevant, and I've set out some time limits which apply. They're quite generous time limits for negligence claims, but as we'll come on to see, if you're simultaneously bringing a negligence and a Human Rights Act claim, the Human Rights Act period is just 1 year from the breach, the date of the breach. So it's sensible to bring a claim as soon as possible. Moving on to Human Rights Act damages claims, both Nicola and Andrew have touched on this briefly. State schools, whether academies or maintained, are public bodies under the Human Rights Act. And the state has positive obligations under Article 3, which we've looked at to take measures to prevent sexual assault in schools. Nicola's taken you to a few recent cases. I just want to remind everybody of O'Keefe and Ireland, which is a case in relation to a sexual assault by a teacher, but deals with the education context and makes it clear that the duty under Article 3 is, first of all, systemic. So to have a framework of laws that provide effective protection and that are adequate. So in other words, what are the policies and practices in the school? To what extent are they following the statutory guidance, etc. There is also an operational duty. So where school authorities know or ought to have known that a child is at real and immediate risk of sexual assault, there's what's called an operational duty to take reasonable measures to protect that child. So you can see already in Joel's case, where you're on notice of an assault and a further one happens, you're, I would say, already in this territory. And then finally, there's an investigative duty to carry out an adequate investigation where a sexual assault is reported to it. And we will all remember, it feels like a recent case, but in fact, it's 4 years ago, which is the Supreme Court case of DSD and the Commissioner for Police, which held that a failure to carry out an adequate investigation into a complaint of an Article 3 breach, a complaint of inhuman and degrading treatment, can give rise to a claim under the Human Rights Act. So the investigative failings don't have to be systemic as such, but they need to be serious and significant. So this comes back to Nicola's point that there is a threshold, but really, if you're talking about a sexual assault on a young child, I would find it very difficult to see when that threshold wouldn't be reached. I just to reiterate what's already been said, Article 8, I think should nearly always be pleaded in these types of cases, because if there's any doubt about the level of severity, or for example, if it's not an assault or violence, but harassment or a verbal incident, then certainly Article 8 would be engaged. That's the qualified right to private life, which we've covered. And also, depending on the circumstances, although more unusually, the right to an effective education is there. So if what's happened has effectively deprived the victim of education for a significant period of time, it may well also be engaged, as may well the prohibition on discrimination, particularly if there are other protected characteristics or the child has special educational needs, etc. So I think everyone really on the call will know this, but just to reiterate that the time limit is a year for human rights damages claims, and generally I think it's better to try to issue within that time and not have to rely on a continuing acts claim or an application to extend time, which can be made. There's case law which makes it clear that you don't automatically get an extension if you lack capacity, although in practice, I am finding that those applications are positively looked at, particularly when it's a child, and particularly in a case of sexual assault. But nonetheless, be careful. It's probably always going to be the lawyer's advice on time limits. And really just some on evidence and strategy. And I only want to begin the conversation around this. And I know Andrew and Nicola, and no doubt many of you will also have some views on this, but these are really complex and sensitive cases. It's sometimes extremely complex to know, to really get to the bottom of what the school did know or ought to have known. And there can be difficulties getting specific details from the child or young person, depending on their age, on their level of trauma. Can they say what date it was? Often not. Can they say what year it was? Sometimes not. So all of those issues come to the fore. There's issues about evidence. What kind of evidence do you need? Well, disclosure of school files, disclosure of social services files, any Ofsted inspections, the police if involved, a witness statement, if not from the child or young person, from the litigation friend. It's also useful to, particularly where you're relying on psychiatric injury, which almost inevitably does and will follow from an incident of this nature. An expert consultant psychiatrist or another medical legal report. So these are just some of the things to be thinking about in these cases. And as we've said, liability is often not admitted. And certainly in Joel's case, we were formally put to proof on some of the incidents in question, and that's not unusual. So just an overview really of the civil claims which can be brought together for negligence and for breaches of Articles at least 3 and 8 in cases of this nature. There is a threshold, but in sexual assault cases where it can be shown that the school should have known or ought to have known or didn't have adequate systems in place, I hope that it provides some reassurance, and I think everybody would expect there to be a remedy in human rights law, because of course that's what it's there to do. So that deals with Human Rights Act claims. And I just want to touch on a third legal remedy, which I do think is a bit different because it's much less historic. So it's more likely to be, as I've said, a remedy if you're seeking prospective relief, but that is judicial review. So for example, if you have a child who you think is at risk and there's something procedurally unfair about the investigation, or you have a child who's still in the same class as the alleged perpetrator and you want to do something about that, obviously it goes without saying that you try to do that with the school using their internal processes. But if you're coming up against difficulties, there is the urgent remedy that judicial review offers, and you can get, as you'll all know, declarations, mandatory orders, etc. Challenges brought on conventional public law grounds can bring damages challenges, but usually not historically. There's a 3-month time limit, as you'll all know, and I think at least consider whether or not you need to exhaust your alternative remedies and what they are. Most schools will have internal procedures to follow. And I did want to, in this vein, just mention a recent case, which is a recent case of Michael Fordham, and it's CHF and CHM. And it deals with a really important issue, particularly in this area, but generally also around, for example, gangs in schools, etc. And it's about whether a school, without formally excluding a pupil, can impose mandatory off-site schooling or safeguarding separations, as they're sometimes called. And the context in this case was a sexual assault allegation against the pupil concerned. The issue was in fact academic by the time it came to final hearing, because the pupil the allegation was against had in fact been permanently excluded then. But Ms. Justice Fordham dealt with the point, which was a statutory construction point, and held in summaries that schools do have this power, that it comes not only from their general management powers, but also with the duty of the local authority to make alternative educational provision under Section 19 of the Education Act 1996, and crucially on the duty that we've touched on a lot this evening, which is Section 175 of the Education Act 2002, the duty to promote the welfare of children. So a really interesting and important case, and it does, I think there's no doubt some detail to be worked out in terms of exactly how it works, but it enables schools to separate pupils, and indeed to remove one pupil off site if that's considered to be necessary. So that's potentially quite a useful thing to be able to request if you're acting on a case where you think that that's needed and appropriate. So I think Michael Fordham has in the past come up in age assessments, and Nicola and I have talked about this with this protective precautionary principle. And I do think I would be surprised if we didn't see this creeping into this area where you have serious allegations, a vulnerable victim, and in particular where there's an issue about continuing with education. So I just briefly wanted to mention that to show the type of remedy that judicial review can offer in some cases. And just the final thing that I wanted to touch on is really what Andrew has taken you through, which is just in all of these remedies that are available, a civil claim for damages under the Human Rights Act or negligence, a judicial review. Obviously, the government guidance point, even with its imperfections, is a useful starting point. And the 4 options that Andrew has taken you to, obviously, disciplinary action, we're looking at your school behaviour policies, and if they have a specific policy, as I think they're encouraged to. And just that it's a very sensitive and careful balancing act, as Andrew has said, including, particularly when they're very young children, the position that the alleged perpetrator is also in, and indeed the use of the language and terminology in those cases. So that's really just intended as an overview, and I'm sure we'd all be really keen to hear your experiences as well. But thank you very much, and I think we still have 10 minutes or so for questions. So I'll just look to see if there are any questions. And while I do, I was going to come just to you, Andrew or Nicola, to see if there was anything that you would add on the legal remedies on sort of practical tips in bringing these claims, or any experiences that you've had that you think it would be useful to share? Andrew, I don't know if you've any thoughts that you want.
Yes, I mean, in terms of evidence, it is a particular hurdle in these very sensitive matters with young children. In the cases that I'm bringing, I have made every effort to not have to speak to a child, to take evidence directly from them. So give consideration to things like disclosure of police statements, but also often you'll see a child in need assessment take place after there has been some sort of disclosure of a sexual offence. And again, they can be very helpful in setting out somebody who has trained in taking that sort of evidence from children. So it's incredibly useful to just look around what resources you have available without having to speak to the child yourself. It is a very sensitive matter.
Thanks. That's brilliant. And as we were saying at the beginning, I mean, the statistics Nicola read out are just so horrifying. And even if we know them, to hear them again, it's just so horrifying. And yet there's not a huge volume of these cases, and there's not a huge volume of certainly judicial guidance on how to handle these cases. So if anybody does have experiences that they'd like to share, please do put it in the chat or the Q&A. I can see something's coming up in the chat. We do have a couple of questions. One from Eleanor: how easy is it to get funding for claims of these types? Which may need to go to Andrew again, but certainly there is funding for human rights claims, subject to the usual legal aid stringent criteria.
Yeah, exactly. Yes. Yeah. I've not. I don't think I've had an application for legal aid. It's not been too much of an issue actually to get funding for these sorts of cases if legal aid's available under the Actions Against Public Authorities contract.
Brilliant. Sorry, go ahead, Andrew.
I was going to say that I think there's a couple of questions coming through.
Oh, I've seen them now too. Thank you. So we've got a question from. I'll start at the top. Alice has asked about if we or if anyone has any experience of the types of disciplinary measures that are normally taken for child perpetrators in practice, and what happens in particular with older children or young adults when the offence is particularly serious. So I've certainly seen permanent exclusions at various stages, sometimes before criminal proceedings or certainly afterwards. So I think the answer to that can be yes, although it very much depends, and I think it is different in primary schools.
Yes, yeah, and I've seen criminal proceedings brought in very serious offences against children where it's resulted in a conviction.
I think referrals to police and social services it's a point. It happens in the more serious cases, but it doesn't always happen in cases which are seen to be more sort of in the middle. Whereas what's helpful about the statutory guidance is that it says that those referrals should be made in those cases. So I think that's a really helpful thing in the guidance, certainly to push for in individual cases. And we have a question from Karen: how much of the statutory guidance applies to independent schools? Does any of the peer-on-peer abuse guidance apply to boarding accommodation in independent schools? Which is a good question, and I understood it to be national guidance as such.
Yeah, I understood that to be the case as well, that it's extended. I don't know directly the answer to boarding accommodation in schools, but certainly more generally, that's my understanding, that it applies equally to independent schools.
That's my understanding too, Karen, and we can quickly check for you if you like at the end and send an email. We have one other question here. Let me just quickly see. From the point of view of a school where an alleged perpetrator is PEX, is the GB expected governing body, that is, I'm out of the way lingo, expected to make findings when the excluded pupil denies the allegations? Very good question. There's been a reinstatement of the pupil and made no findings, and then he then did it again. So that's a question, I suppose. First of all, does the statutory guidance say very much about that? It's difficult to imagine how you could deal with it without making findings if it's particularly serious. I would have thought that's part of an adequate and thorough investigation, but do any of you want to come in?
I think it does talk about investigations on balance of probabilities when it's looking at schools trying to assess the facts on this, but it is it's an incredibly delicate situation. It's a very complex issue.
I suppose I think it would also depend, wouldn't it, on what your evidence is that's before the governing body, because if it were very compelling and clear, then I can see there being more of a difficulty in not having findings, and then when there's a repetition of the conduct, there being no findings again. So I suppose it would, I mean, as with all of these things, it'll depend on the individual circumstances.
I agree. And some more questions on a similar line coming in, which about the statutory guidance / case law applying where both pupils are in the school, but it's outside the school premises. And I can certainly say that what I spoke about, which is the civil claims and negligence and the Human Rights Act, can apply. It can be more difficult to attribute the requisite knowledge, but certainly there's no reason in principle why it can't happen. And I understand the statutory guidance is probably similar, but I'll wait to see if anybody else wants to come in on that. But certainly I think from a policy point of view, most policies will deal with both instances and will investigate both instances. Certainly if both children are in school, the difficulty that you have is that you have to be satisfied that it won't happen on school premises again. Yes,
one of the case summaries in the advice is actually dealing with an issue of an incident that took place outside of school and sharing of images, and how that can come within school settings and in terms of further harassment, sexual harassment or bullying. So my understanding was that it's looking holistically on a safeguarding point for the children that are within your care. So there's a potential for something outside school to come within a school setting.
And contribution from Nikki Cameron, I think. Andrew, you asked about training for assessment of HSB. In my multi-academy trust, we have trained at least 2 staff in each of our 43 academies in the Brook traffic light tool, which I think is wonderful, what we want to see, because I think the point about all of this is that we don't really want lawyers to be involved, because when they are, it's often at a stage where damage has already been done. So that sort of training, etc., is wonderful, and thank you for sharing it. I think that may be us on our final. I think we may have covered all the questions. Andrew or Nicola, is there anything that you would like to say just by closing?
Well, it's just that it's such a crisis, and I think really the best thing that we can do is just, as you say, it's a matter more of prevention and taking steps as early as you can, rather than at the end bringing claims, because the claims then, given the sensitivity, given the difficulty of the evidence and obtaining the evidence, and also the impact on those involved of the litigation itself, I think this really is an area where early intervention is key.
Yes, yeah, I agree. This is a very delicate, sensitive issue, and it is a very widespread issue, and it is an issue that we've been aware of now for quite some time, since that Women's Inequality Select Committee all those years ago. So I think we're beyond the point where people can sort of say that they weren't aware of this issue, and we really sort of have to grasp the nettle. So it's heartening to see so many people coming today and just having this open dialogue about this very complex issue that does need to be tackled.
Thank you both very much. I agree completely, and hope that those who've attended have found this talk to be helpful just in understanding the parameters of law and practice, and in particular if really required, to understand what the legal remedies can be, whether under common law or under the Human Rights Act, or the ever-present option of judicial review. So thank you all very much for coming and for all of your work in this area. And I know the slides will be circulated. So in the meantime, have a lovely evening, and thank you very much again.
Thank you.
Thank you.
Bye.
Bye now.